Abigail Ngobene, our legal expert, is now ready for us to engage us on this matter. Very good morning to you, Abigail. 3 judgments, split 3 ways, but the majority judgment finding that the president has made a case for an interdict. Your take?
Yeah, I think that it's difficult, of course, I should say, from premise that one have not seen the reasons, we have not seen how the court judicially arrived at that particular decision. But you'd have noted from the brief court processes that there are 3 different judgments, which, of course, one cannot pin on how the court finally arrived at that. But the majority of the court says he has made out the elements or rather the case for an interdict, which is an interim interdict in nature. And the interim interdict in nature disposes of the matter. And of course, we're gonna hear the actual review process to hear exactly on whether or not the report is set aside. But this step of the proceedings is to say that Parliament should hold a little bit. The president have satisfied those elements, of course, as well as the balancing exercise that the court might have gone through to check the irreparable harm that the president will suffer as compared to stopping the work of Parliament.
Mm-hmm. Now that you rightfully state that the focus moves to that Section 89 report, just help us understand here. Our understanding is that those 3 members of that panel, which were led by Justice Sandile Ngcobo, are now functus officio, meaning their work is completely done. They have no interest in that specific report. So who takes it to court to defend it? Who will defend this specific report?
I think in the main, remember that the Section 89 it's a hand of Parliament. And of course, it's Parliament that, of course, should defend the matter through the office of the Speaker. But in the main, other parties can also jump in. Political parties can jump in as and when they have satisfied an application to be parties and be joined into the proceedings. But as well, the amicis as well can come and argue. But to defend the matter in the main, the Speaker or the Parliament should be able to be the ones that defend the matter in its entirety. It's the report of Parliament, and that was the section work of Parliament.
Mm-hmm. But judging by the position that the Speaker took, at least in this urgent interdict where she went on to file a notice to abide by any judgment, one would assume possibly that even with that specific matter, they might not be looking to defend it, but possibly again file a notice to abide by any judgment. But when looking at some of the arguments from Wim Trengove when this matter sat before the Western Cape High Court, he had gone on to argue that it seems that that panel would have applied an incorrect legal standard. But the argument from some was that they were limited in scope from the onset. If they were not allowed to subpoena anybody or to cross-examine anybody, it essentially was an invitation at that time for anybody who had information to just bring it before the panel. So could it be that they would have used an incorrect legal standard if their scope wasn't even widened?
It is difficult to really come up with a concrete opinion on that kind of a submission. Remember that the finding of the Section 89 report by the retired Justice Ngcobo is to say that the president, rather there is a prima facie evidence, or rather there is a prima facie case for the president to answer. And that does not really mean that the president is guilty of any wrongdoing. It does not necessarily even mean that it is a final in its nature. Evidence is still going to be led at an impeachment stage. But as it stands, the committee finds that there is something that the president must answer to. And from where I'm sitting, I really do not think that could have been something that is far-fetched or does not really have a legal support. But when you look at what you have just said, to say that they had a limitation in scope, that was just an inquisitorial, rather, or to say something that it's just an investigative process to come up with preliminary evidence to say, is there any wrongdoing given the legal applications, or rather the statutory provisions on how the monies in the Phala Phala farm were handled and all that. Is there any possible violation to the legal prescripts? And that's what the report is saying, to say from where they stood, there is something that in their view, the president could have a case to answer before the Parliament.
Now, Abigail, again, in the absence of the reasons for that specific majority judgment, we go back then again to some of the arguments by Wim Trengove. Now, he went on to also state that before the Western Cape High Court, he had gone on to state that, according to them, that Section 89 report almost lacked bad faith on the part of the president, that they couldn't necessarily pinpoint bad conduct on the part of the president, which takes us again back to that argument of this was very limited in scope.
Yeah, it does. It does to say, I'm frozen, but I don't know if you can hear me, but it does. But one would, of course, wait for the review judgment to also hear the arguments that will be advanced then, because the issue of scope of the work of that committee will be ventilated in details to see to it on what exactly was commissioned for this particular committee to work on, what was their parameters to work on, what was their powers, and if they acted ultra vires, we would hear from the arguments and we would hear with documents that are presented and of course argued to say this was what they ought to have followed and they went beyond, and anybody that goes beyond the powers that are commissioned to them, of course, will be called to order and they will be found to have acted ultra vires. And let's rather wait for them to hear in a proper ventilation to say, have they acted beyond what was the scope? Have they acted beyond the powers that were given to them in terms of their constitution?